So, should Magistrate Smith of the Roodepoort Magistrates Court have asked Ntuthuko Shoba for more information, or was the onus actually on him to prove exceptional circumstances exist which are in the interest of justice for bail to actually be granted? Well, the Johannesburg High Court will have to make that determination this morning as it hands down judgment on Shoba's third bail attempt. Shoba, as you remember, is charged with the premeditated murder of Tshegofatso Pule, who was 8 months pregnant at the time of her killing. Newzroom Afrika's Mnisi is outside court for us. He joins us now live. It's an interesting question, Linda, around who should have provided this information. Should it have been drawn out of Ntuthuko Shoba, or was the responsibility on him to prove why this bail should actually have been granted?
Absolutely, and especially given the fact that the defense is now placing that particular judgment, that particular argument in this appeal. You'll remember that initially when he applied for bail, if I remember correctly, his legal team then was Advocate Luyanda Nyangiwa, stating that in fact Ntuthuko Shoba was employed, he had a stable address, he had to be moved. At the time when this matter was in the public eye, had to be moved to his mother's house. He could lose his job, in which he earns a good salary, about 36,000 rand, and that he had no criminal record. So this was a law-abiding citizen who, has no previous criminal charges or, convictions, saying that there are no reasons for him not to be granted bail. But the state saying that there was nothing exceptional about what Ntuthuko Shoba had brought at the time. Being employed, I remember Advocate Vaseka Temeki, who was the prosecutor in this matter, saying that there's absolutely nothing exceptional about being employed. The onus was on the accused, being Ntuthuko Shoba, to provide those exceptional circumstances. The magistrate reaching to a conclusion that in fact there was no sufficient information given for the court to work with in terms of why he should be granted bail. Now, the defense, we know, is the third lawyer in this matter. So the second one was, of course, Shadisi Tole, who was representing Ntuthuko Shoba through the second bail application. And, just before that case was moved here to the Johannesburg High Court. Now, the defense team arguing that, in fact, the court should have used its discretion in terms of using Section 60, subsection 3 of the Criminal Procedure Act, in which it could have sought information from Shoba if it felt that he did not bring about enough information, because the section itself empowers the court to request for that particular information. But the state, arguing that, well, that cannot be read in isolation. There is subsection 11, which speaks about the schedule of this offense. It's a Schedule 6 offense, which means that Ntuthuko Shoba should provide exceptional circumstances which are in the interest of justice for him to be granted bail.
One wonders whether Shoba has any more options after this if it doesn't work out. I guess only time will tell. For now, let me thank you indeed for that take. Linda Mnisi, live to us there from just outside the Johannesburg High Court.